My name is David Payne, and I practice law at the law firm of David R. Payne, PA. You can find us on the web at www.drplawfirm.com. Our telephone number is 828-258-0076. Today I want to talk to you a little bit about driving while impaired and the levels of punishment associated with driving while impaired. Now, in North Carolina, there's a scale that the court will utilize, and you will fall into this scale for purposes of sentencing. So a lot of people will call us up on the telephone and ask us, what am I facing? What will the court be fining me? What will my jail time be, if any? And so I feel like it's important for us to kind of go through this. A lot of these things have changed a little bit. December 1st is a new date with respect to new laws related to DWI, and at our law firm we're on top of it, we're ready, and we're certainly here to answer your questions. But let's kind of walk through this. The court considers things like mitigating and aggravating circumstances when it makes a determination as it relates to where you're going to fall within the scale. You want to, obviously you don't want to have any DWI charge at all, but if you're charged with driving while impaired and you're found guilty, you can find yourself in one of 5 categories. 5 being the least severe, 1 being the most severe. Now, as you go from 5 to 1 or 1 to 5, depending on how the court looks at your circumstances, what you're going to be facing is a balancing test that the court conducts as it relates to aggravating circumstances and mitigating circumstances. The term aggravating means it makes it worse. For example, when someone aggravates you or agitates you, it makes the situation worse. The term mitigating means it takes away from the aggravation, or it makes it less bad in one sense. So when you hear these terms bantered about, that's what the court is talking about. Aggravating circumstances are circumstances that the court takes into consideration like this. Let's say you take a breathalyzer test and you blow 0.15 or greater. Now in North Carolina, legally, it's 0.08 to be considered intoxicated. Now, don't take that to mean that you will not get charged if you blow a .06. Like I said on other tapes, they will charge you, depending on how you act and how you respond. So I've had clients come in with a .07, .05, even a .03 at one point. But if you have a .15 blood alcohol content or greater, that will be considered an aggravating factor. If there was a dangerous accident, meaning that if you hit someone else while driving, while impaired, that will be considered an aggravating factor. If you have prior convictions which are older than 7 years, in other words, if it was 7 years and 1 day and you had a DWI conviction at that time, they'll look at that prior conviction as an aggravating factor. Now, what they consider to be grossly aggravating, in other words, over-the-top aggravating, would be if you had a DWI charge within the last 7 years. So if it's 6 years and 11 months and 29 days and you get a DWI, that's going to be considered a grossly aggravating factor, which will move you up in this scale to where you don't want to be. If there's a child under the age of 16 in your vehicle and you're intoxicated, they will see that as a grossly aggravating factor. If you're driving a vehicle and you're intoxicated and your license has been revoked, that's a grossly aggravating factor. So the court will take into consideration all of these things. Now, the word mitigating, like we said, kind of takes away from that. So let's say that you blew a .09, but you had a child in the car under the age of 16. Well, the court's going to look at these scales and it'll say, well, grossly aggravating factors, where do they fall? In 3 or 2? Do do they fall in for? That's where we come in. We really help make those arguments by virtue of research and case law, and by virtue of our experience in the courtroom. It's important for you to understand these things. It can be very technical at times and very confusing, even to the best judges. A lot of times, a prosecutor will simply say, I think they're a level 3. Well, a level 3 versus a level 4 is a difference between 6 months or 120 days. Or a $1,000 fine and $500 fine. Well, that's a big difference. If you've had a pretrial assessment, which we have great coordination in our office to get you through your pretrial assessment, that's all done before we ever even step into the courtroom. And it makes believe that basically it takes the court to a point where you have been reviewed and you have been determined to have not a drinking problem. Another mitigating factor is whether or not you have a safe driving record. We pull your driving record, we go to the DA, we go to the judge, and we say, listen, here's the situation. John Doe has done a good job driving, made a mistake on New Year's Eve party, made a mistake at a birthday party, drank more than .08, and as a result was charged with DWI. But the safe driving is a mitigating factor. We want to have more mitigating factors than we want to have aggravating factors. And that goes into the final part of what I'm telling you about today. We want you at a level 5, if we can get you there. Level 5 is a $200 fine, plus you're going to have court costs. Now those court costs vary. North Carolina is having some economic difficulties, and as a result they up the court costs. And so the client thinks, well, I'm only going to have to pay $200. No, that's not true. You're going to have to pay $200 plus whatever the court cost is. There'll be a 60-day imprisonment associated with the DWI. Don't freak out. That imprisonment will typically be suspended. So you'll hear the word suspended. If during the period of time, those 60 days, you do something else, like violate any of the court's orders, drive when you shouldn't drive, that 60 days can be invoked and you can find yourself in jail. You'll have 24 hours of community service. You'll have to have that substance abuse assessment, the pretrial assessment like we talked about. If there are some aggravating factors, meaning that you may have blown a .15 or greater, you might find yourself at a level 4. A level 4 is a $500 fine, 120 days in jail, 72 hours of community service. Now you can see as we're going down from 5 to 1, you find yourself getting in the aggravating zone. Let's say you had a previous DWI within 7.5 years, let's say, but there was an accident. Someone was hurt. The court will take that into consideration. You may find yourself at a level 3, 6 months, 72 hours, $1,000 fine. And as we go down, level 2, $2,000, 12 months. 72 hours of community service, 90 hours of continuous alcohol monitoring, which is a new requirement under the law. And of course, if you find yourself at a level 1, you don't want to be there, but if you find yourself there, you're looking at a minimum of a fine of around $4,000, 24 months in jail, and the court can levy what other punishment it wants to. Now, please don't think that that's all you can be charged with. There's a myriad of charges that can be assessed to a DWI situation. Our firm is committed to limiting those charges. Our firm is committed to making sure we weave you through this maze and we make sure that you get at least a fair and accurate representation of where you should fall within the level. You'll go into court, you'll know what you're looking at, and you'll know how to be prepared. So we encourage you to give us a call, 828-258-0076, or visit us on the web, www.drplawfirm.com. And again, we would encourage you, don't drink and drive, but if you do and you get caught, call us. Thanks.